Hello everyone and welcome to the January 2026 edition of MAIPF Monthly. Happy New Year to everyone. This month's presentation is brought to you by Senior Partner Mark Masters and myself, Executive Partner Caitlin Milroy. Today's topics first include our usual most recent case law update. The first case law update is on the unpublished opinion per curiam of the Court of Appeals that was issued on December 12, 2025 of Leo Pellot, individually and next friend of AKB, minor, versus State Farm Mutual Automobile Insurance Company and MAIPF, MACP, and currently unnamed assignee of the MACP. The second case we will discuss is the recent published opinion of the Court of Appeals that was issued on December 18, 2025 of Walter Love and Thrive Physical Therapy, LLC versus Lashawn, Rudolph and Allstate Property and Casualty Insurance Company, Allstate Insurance Company, Auto Club Group Insurance Company, and the Hanover Insurance Company. Lastly, we will focus our discussion on the trending topic of PIP litigation pertaining to MCL 500.3107 and when exactly PIP benefits are incurred per the No Fault Act. For this, I will give a brief overview on the topic and statute. There's also a related recent unpublished opinion per curiam of the Court of Appeals of S. Baxter Jones versus Esurance Insurance Company that was issued on November 25th, 2025 that will be discussed. The first case we will talk about is the recent unpublished opinion per curiam of the Court of Appeals that was issued on December 12, 2025 of Leo Pellot, individually and next friend of AKB, minor, versus State Farm Mutual Automobile Insurance Company and MAIPF, MACP, and currently unnamed assignee of the MACP. This case discusses the necessary requirement under MCL 500.31020 that policy cancellations by an insurance carrier require written notice via mail to the address last known to the defendant of the policyholder. Specifically, MCL 500.3020 subsection 1b says, except as otherwise provided in subdivision D, that the policy may be canceled at any time by the insurer by mailing to the insured at the insured's address last known to the insurer or an authorized agent of the insurer with postage fully prepaid, not less than 10 days written notice of cancellation with or without tender of the excess of paid premium or assessment above the pro rata premium for the expired time. In this case, plaintiff Leo Pellot, individually and as next friend of his minor daughter AKB, sought PIP benefits arising from a serious automobile accident that occurred on November 30th, 2022 in Wyoming. At issue was whether defendant State Farm had effectively canceled Pellot's policy before the accident. State Farm issued plaintiff a renewal policy effective July 14, 2022. At that time, plaintiff resided in Grand Rapids, Michigan, but he later moved to Wyoming during the summer of 2022 and arranged for mail forwarding. In August 2022, plaintiff contacted the office of his insurance agent and submitted a formal address change to his Wyoming residence. State Farm's agent testified that address changes typically take several weeks to process at the corporate level. Plaintiff experienced difficulty making timely premium payments. When he eventually made late payments for July and August, he failed to make the required September 20th, 2022 payment. On September 27, 2022, State Farm mailed a written notice of cancellation warning that the policy would be canceled on October 12th, 2022 if payment was not received. Critically, the cancellation notice was mailed to plaintiff's former Grand Rapids address, not his updated Wyoming address. State Farm asserted that it also sent text message reminders regarding non-payment and impending cancellation, though plaintiff denied receiving those. Plaintiff made no further payments and State Farm treated the policy as canceled prior to the subject accident. Following the accident, plaintiff initiated two separate lawsuits. The first was in Kent County Circuit Court for third-party bodily injury negligence claim and uninsured/underinsured motorist claim. Summary disposition was granted to State Farm as to the UM/UIM claim, as the trial court concluded that the policy had been canceled due to non-payment of premiums. The second suit was a PIP suit against State Farm filed in Wayne County Circuit Court, which is the present case we're talking about. In the PIP case, State Farm moved for summary disposition under MCR 2.116 C10 arguing that the policy was properly canceled before the accident, and the Kent County Circuit Court ruling collaterally stopped plaintiff from relitigating coverage. The trial court ultimately granted State Farm's motion, reasoning that plaintiff knew that he had failed to pay premiums and had agreed to electronic communications regarding his policy. Plaintiff appealed as of right to the Michigan Court of Appeals. In its ruling, the Court of Appeals relied heavily on the case of Cousin versus Auto Club Insurance Association, which held that an insurer must mail a cancellation notice to the most current address known to either the insurer or its agent. And mailing a notice to a former address renders the cancellation ineffective, even if the insured later receives actual notice or knows that cancellation is likely. And lastly, defective mailing is not cured by actual notice. The court further cited the case of Rollman versus Hawkeye Security Insurance Company for the principle that statutory requirements governing insurance policies are incorporated into the policy by law and cannot be contractually altered. Lastly, the case of Monat versus State Farm Insurance Company was cited in connection with the collateral estoppel analysis, emphasizing the need for a valid and final judgment and equitable considerations. The Court of Appeals ultimately held that State Farm failed to comply with MCL 500.31020 because it mailed the cancellation notice to plaintiff's former address despite having updated address information on file prior to mailing. Under the case of Cousin, this defect rendered the cancellation ineffective as a matter of law, regardless of whether plaintiff had actual or constructive notice of non-payment. The court rejected State Farm's argument that electronic communications or text messages could substitute for the statutory mailing requirement, concluding that parties cannot contract around mandatory statutory terms governing insurance policies. The court declined to resolve the collateral estoppel issue, finding that it involved unresolved factual and equitable considerations better addressed on remand. The Court of Appeals then reversed the trial court's grant of summary disposition and remanded the case for further proceedings consistent with its opinion. The second case we will discuss is the recent published opinion of the Court of Appeals that was issued on December 18th, 2025 of Walter Love and Thrive Physical Therapy, LLC versus Lashawn, Rudolph and Allstate Property and Casualty Insurance Company, Allstate Insurance Company, Auto Club Group Insurance Company, and the Hanover Insurance Company. This case discusses the order of priority for PIP benefits under MCL 500.3114 subsection 5 and the effect of an insured's election to decline PIP coverage, in this case in a motorcycle versus motor vehicle accident. Further, the case discussed the issue of whether a motor vehicle was involved in the accident. On May 27th, 2021, plaintiff Walter Love was operating a motorcycle attempting to merge onto the Southfield Freeway in heavy stop-and-go traffic. According to the police report, a vehicle failed to slow, initiating a chain reaction collision involving plaintiff's motorcycle and 5 other vehicles. Plaintiff's motorcycle was struck after multiple rear end and side-swept collisions occurring among the vehicles ahead of him, throwing plaintiff from the motorcycle. One of the vehicles in the chain involved in the accident was a Volkswagen Jetta driven by Grace Pfeiffer. Pfeiffer testified that she was clipped from behind while attempting to avoid a rapidly approaching vehicle and that the striking vehicle then continued through the line of traffic, eventually hitting plaintiff. Plaintiff had limited recollection of the collision and could not identify which vehicle struck him. One of the vehicles involved was owned by Lashawn Rudolph and insured by Auto Club. Rudolph had selected a $250,000 PIP limit and excluded only herself from PIP coverage. No insurer conceded priority, resulting in assignment of the claim to Farmers Insurance Exchange through the assigned claims plan. Plaintiff filed suit alleging a bodily injury negligence claim along with claims for underinsured motorist benefits and PIP benefits from multiple insurers in this case. The multiple insurers filed motions for summary disposition under MCR 2.116C10. Auto Club argued it was excluded from priority under MCL 500.3114 subsection 6 because its insured elected to exclude PIP coverage. Hanover and Citizens argued that the Volkswagen Jetta was not, quote, involved, unquote, in the accident for priority purposes. The trial court denied Auto Club's motion, finding it remained in the order of priority, dismissed Hanover but allowed Citizens to be added as a defendant, and found genuine issues of material fact regarding vehicle involvement. The Court of Appeals initially denied leave, but the Michigan Supreme Court remanded the case for consideration as on leave granted. Auto Club appealed, Citizens in Hanover cross-appealed. The court had 2 points of analysis. The first was Auto Club's priority status and the present PIP exclusion. The second was the alleged involvement of the Volkswagen Jetta in the accident. First, as it pertains to Auto Club, the court found that defendant Rudolph did not qualify for a complete PIP opt-out under MCL 500.3107D because she lacked Medicare Parts A and B. Her selection of option 4, that $250,000 PIP limit, merely excluded herself, not all claimants. The court noted that statutorily, exclusions under MCL 500.3109A cannot apply to non-household third parties, such as plaintiff here. Because plaintiff remained eligible to claim PIP benefits under the policy, Auto Club was not removed from the priority order. The court found that the trial court correctly denied summary disposition, as Auto Club remains within the order of priority under MCL 500.3114 subsection 5. Second, the court discussed the contention as to whether the Volkswagen Jetta was involved in the accident as required by MCL 500.3114 subsection 5. Prior case law establishes that physical contact is not required, the vehicle must actively contribute to the accident, and there must be a causal nexus beyond a mere fortuity. Overall, the court found that the evidence showed that the Volkswagen Jetta was struck during the collision sequence, took evasive action due to a rapidly approaching vehicle, and was part of a contentious chain of events culminating in plaintiff's injury. A reasonable jury could find that the Jetta's involvement was active and causally connected, even without direct contact with plaintiff. Overall, the court found that there was a genuine issue of material fact regarding involvement. Summary disposition was properly denied. The Court of Appeals affirmed the trial court's ruling in all respects, and ruling that Auto Club is not excluded from priority. The involvement of the Volkswagen Jetta presents a jury question, and no costs were awarded. The significance of this ruling is that it, 1, clarifies limits on PIP exclusions under post-reform no-fault law. 2, it reinforces that motor vehicle involvement under MCL 500.3114 subsection 5 is broader than physical impact. And 3, it confirms that coverage elections, excluding only the named insured, do not defeat third-party claims. I want to now focus our discussion on the trending topic of PIP litigation pertaining to MCL 500.3107 and when exactly PIP benefits are, quote, incurred, unquote, per the No Fault Act. The statute of MCL 500.3107 subsection 1A states PIP benefits are payable for, quote, allowable expenses consisting of reasonable charges incurred for reasonable necessary products, services, and accommodations for an injured person's care, recovery, or rehabilitation, unquote. In sum, the statute calls for allowable expenses to be reasonably necessary, and incurred. Prior case law establishes to incur means to become legally liable, and that's according to Proudfoot versus State Farm, and proofs require that services were rendered and costs incurred. That's under Douglas versus Allstate Insurance Company. There is a related recent unpublished opinion per curiam of the Court of Appeals of S. Baxter Jones versus Esurance Insurance Company that was issued on November 25th, 2025 that will be discussed. The facts of this case are in 2005, plaintiff S. Baxter Jones, a Michigan resident, was involved in a motor vehicle accident in Kentucky. He alleged that the accident caused numerous serious injuries. Plaintiff sought PIP benefits, including medical expenses, lost wages, replacement services, and extensive attendant care services. Defendant Esurance was plaintiff's insurer. Years later, plaintiff claimed ongoing disability and submitted attendant care logs identifying numerous individuals as paid care providers. Esurance disputed both the legitimacy of these attendant care claims and the causal connection between plaintiff's ongoing condition and the 2005 accident. Esurance also identified subsequent incidences, including a 2014 arrest, related injury, and other post-accident medical events, which Esurance argued constituted intervening causes, severing any causal link to the 2005 crash. Plaintiff initially litigated insurance claims in Kentucky, followed by extensive procedural history resulting in the matter proceeding in Michigan. In 2022, the trial court granted partial summary disposition, barring claims incurred before July 7, 2016. Esurance moved for summary disposition under MCR 2.116C10 on two primary grounds. First, plaintiff did not incur compensable attendant care expenses. And 2, plaintiff's damages were attributable to intervening accidents, not the 2005 crash. The trial court granted partial summary disposition, dismissing attendant care claims associated with numerous identified providers, and denied summary disposition on the issue of intervening causation, finding it a question of fact. Plaintiff unsuccessfully moved for relief from judgment under MCR 2.604 and MCR 2.612. The trial court ultimately dismissed the remaining claims in April of 2024, preserving appellate rights. Plaintiff appealed, Esurance cross appealed. The Court of Appeals held that plaintiff failed to establish that attendant care expenses were incurred because numerous listed providers testified they acted voluntarily or did not expect payment. Some providers were paid by other sources, such as Medicaid agencies. Plaintiff failed to submit admissible evidence showing contractual liability or unpaid bills, and plaintiff's response to the motion did not address the core legal issue. Accordingly, the Court of Appeals found that summary disposition on attendant care claims was proper. As to the issue of causation, on Esurance's cross appeal, the court held that summary disposition should have been granted because defendant presented evidence of subsequent injuries, including a 2014 incident and later falls. Medical records showed plaintiff was ambulatory years after the 2005 accident. Plaintiff failed to rebut defendant's causation evidence with admissible proof and mere assertions that some portion of damages related to the 2005 crash were insufficient. The court overall 1, affirmed the dismissal of plaintiff's attendant care claims, and 2, reversed the trial court's denial of summary disposition on causation. The result was that a finding that Esurance was entitled to summary disposition on all remaining claims, and plaintiff's case was dismissed in full. That concludes the January 2026 edition of MAIPF Monthly. If you have any questions, comments, and/or concerns, please feel free to reach out to myself, Caitlin Milroy, or Mark Masters directly through the contact info in the corresponding slide. Thank you all for tuning in. Be sure to tune in next month for the latest case law update and trending topics in the PIP world. Take care, everyone.